Please welcome the moderator for our closing session, Joan Gable, Chancellor of the University of Pittsburgh.
But I don't think we've ever met before.
We haven't.
Good morning, everybody. So I apologize for interrupting morning conversations, but I have the pleasure of introducing and hosting our closing session speaker. But before I do, I want to make sure we acknowledge that today is Veterans Day, and that I know all of us are very grateful for the sacrifice and service of our veterans. Could we give all of our veterans in the room a round of applause, please? So it's my pleasure to introduce Erwin Chemerinsky. So Erwin is the Dean and Jesse H. Choper Distinguished Professor of Law at the University of California, Berkeley School of Law. Prior to assuming this role in 2017, he was the founding dean of the University of California Irvine School of Law and a professor at Duke Law School, University of Southern California Law School, and DePaul College of Law. He is the author of a mere 20 books, with the most recent being No Democracy Lasts Forever: How the Constitution Threatens the United States. He has a new book coming out in January with UC Irvine Chancellor Howard Gilman, who I think many of you heard from earlier in the conference. And that book is entitled Campus Speech and Academic Freedom, A Guide for Difficult Times. That might be the best book title I've heard in quite some time. He is the author of over 200 law review articles and is a contributing writer for the opinion section of the Los Angeles Times. Dean Chemerinsky writes regular columns also for the Sacramento Bee and the American Bar Association Journal. He is still arguing cases, largely appellate cases, including in front of the United States Supreme Court. And in 2022, he was president of the American Association of Law Schools, or AALS. So please join me in welcoming Erwin Chemerinsky.
Thank you so much. Thank you so much for the incredibly kind introduction and warm welcome. It's really an honor to get to speak with you, and it's very special to me because I admire what each of you do every day. No democracy lasts forever. Democracies are there until they're not. We're all familiar with countries that once were democracies, but no longer are democracies. It would just be hubris to believe that there's something that makes the United States immune from the forces that threaten other democracies. One characteristic of every authoritarian or would-be authoritarian rule is the way they go after universities. What we have seen in the last 9.5 months is unprecedented in American history. I was asked to speak briefly this morning about the attack on universities, the law, and the courts. So I want to divide my remarks into 3 parts. First, I want to talk about one aspect of the attack on universities that's familiar to everyone in this room, and that's the financial assault that we're seeing right now. Second, I want to talk about what the law says about this. And third, I want to raise the question whether the courts will be there to protect universities. In terms of the first of these, it's familiar to everyone, so I can be brief. The Trump administration has recognized that American universities have 4 financial vulnerabilities. They're very dependent on federal money, they're very dependent on foreign students, they're very dependent on tuition, and they're very dependent on philanthropy. And it's important to put these together and see how there's an attack on each of these. With regard to the dependence on federal money, billions of dollars of money to researchers have already been cut off. On June 1st of this year, according to the Department of Government Efficiency website, $325 million of grants to University of California faculty and researchers had already been terminated. But as we researched this, we found it was a tremendous underestimate. Many grants were not included. Sub-grants were not included. The estimate is probably closer to $1 billion as of that moment in time. We all are familiar with the effort to cut off huge sums from particular universities. $400 million from Columbia, $2 billion from Harvard, $584 million from UCLA, similar large sums from schools like University of Pennsylvania, Brown, Cornell, and Northwestern. And as university administrators, You're so familiar with the way in which the administration has tried to limit indirect cost recovery, and what the effect is that on research. Second way in which the administration has gone after higher education financially is by targeting foreign students. I'm sure you saw the statistic that 27% of the students at Harvard are international students. This is similar at universities across the country. This is true at both public and private universities. Let me just speak of my law school. We have an LLM program that's exclusively foreign students. When there was the holdup on visas last spring, my provost said to me, "What's your contingency plan if you can't get LLM students?" I said, "That's $20 million of our budget each year. We don't have a contingency plan." Much has been done to try to attack the ability of universities to have international students. Visas were revoked. That, of course, strikes terror in the heart of those in the United States on visas, and it makes it much less attractive for international students to come to the United States in the future. There was a time when visas were suspended, and it was uncertain whether individuals would be able to come to the United States. The proposed compact on education that was released on October 1st so the university could not have more than 15% international students and no more than 5% for any country. A devastating financial effect on many universities. But there's also the attack on tuition. I wish there had been more publicity to the provisions of the large bill adopted in July and what it's going to mean for graduate and professional school education. As you know, it eliminates the Grad Plus student loan program. 43% of the students in my law school are right now receiving loans under that program. It puts a cap on graduate student loans and professional school loans. For graduate students, the cap is $20,500, maximum lifetime borrowing of $100,000. For professional schools, like for law schools, the maximum borrowing year is $50,000, and lifetime it's $200,000. The tuition at my law school, a public law school this year, is $65,000 for in-state students and $80,000 for out-of-state students. That's not cost of attendance, that's tuition. If borrowing is capped at $50,000 a year, what's going to happen? Will it be private loans? On what terms? And what about those who can't qualify? Will it be that law schools, graduate schools, will only be for those who are rich enough to pay for most or all of it themselves? Again, to refer to the compact on higher education that was proposed on October 1st, it would say that schools could not increase tuition for 5 years. It would say that schools with endowments of a certain level must provide free education for all students in the STEM fields. How possibly could this be paid for? Tuition goes up because costs increase each year. If revenue does not match costs, then programs have to be cut. The education of students will suffer. And finally, there's the attack on philanthropy. Another aspect of the large bill is for universities with significant endowments to pay much larger tax on those endowments. Again, you can ask, where will this money come from? So in the second part of my remarks, I want to address, is what's been done legal? And the answer is, some of it is clearly illegal, but some of it is legal and unlikely to be challenged in courts. Let me talk about each of the 4 types of actions that I just referred to. What about the cutoff of funds? I think the termination of grants that we've seen, whether it's to researchers and faculty or to universities, is clearly illegal. Congress can set the terms of grants. The president has no authority to set additional terms. Congress appropriates funds. The president has no authority to refuse to expend those funds. In fact, in 1974, Congress passed the Impoundment Control Act that made clear the president cannot refuse to spend funds that are appropriated by Congress. The cutoff of grants violates both federal law and the Constitution. A couple of federal courts have already concluded this. One is a case that I'm involved in as lead co-counsel. It's a lawsuit brought on behalf of faculty and researchers at the University of California. It succeeded at this point in getting over $500 million in grants restored. The federal judge in San Francisco, Judge Rita Lynn, found that the termination of grants violated the Federal Administrative Procedures Act. The Administrative Procedures Act says that federal government actions can't be arbitrary, capricious, or an abuse of discretion. As Judge Lynn found, many of the grants were terminated just because of keyword searches. They plugged in the word diversity in the computer and then ended grants that used the word. So one of our plaintiffs was doing work on plant diversity and had the grant cut off. Another was doing work on the diversity of the microbes in the human gut and had the grants cut off. For many of the grants, it's inexplicable why they're terminated. And she ordered that the grants that had been cut off from agencies like the National Science Foundation, National Institute of Health, Environmental Protection Agency, National Endowment of the Humanities be restored. But she also found that the termination of grants violated the First Amendment. Although the government has great latitude in choosing what to fund, it can never discriminate based on a viewpoint. The Supreme Court has made clear that the government can't cut off funds for, quote, a censorious purpose. Yet the administration was explicit that it was doing so to try to eliminate discussion of particular topics, especially those that are diversity, equity, and inclusion. And Judge Lynn enjoined the termination of grants, ordered them restored. Similarly, in Boston, Judge Allison Burroughs found that the termination of grants to Harvard University violated the First Amendment. My hope would be that these two lawsuits provide a model for litigation elsewhere in the United States to protect universities that had grants terminated. But one caution here. While the termination of grants is illegal, that doesn't speak to non-renewal of grants in the future and funding in the future. And there the government has far more discretion, and there it's going to be much harder to bring legal challenges. What about visas? Here there's a crucial distinction about whether we're talking about those who are currently on the United States in a visa or those who are in foreign countries who don't yet have a visa. For those who are in the United States in a visa, they are protected by the Constitution and laws of the United States. They have due process rights. Their liberty to remain here on their visa can only be terminated if there's due process provided. So last spring, when the Trump administration terminated visas from many international students, a federal district court in Georgia issued an injunction stopping the termination of visas. Likewise, those who are in the United States on visas have First Amendment rights. The Constitution protects persons, not citizens. It says no person shall be deprived of life, liberty, or property without due process of law. No person shall be denied equal protection of the laws. In 1945, in Bridges versus Wixon, the United States Supreme Court expressly held that visas, status to be in the United States, cannot be revoked on account of speech. So when the Trump administration revoked the visas of individuals like Mahmoud Khalil on account of their speech, courts responded and said that violates the First Amendment. But if we're talking about those who are not yet in the United States, the Trump administration has almost unfettered discretion whether to grant visas. There is no due process right, there is no First Amendment right for those who have yet to be issued visas. And if the Trump administration wants to restrict visas in the future, there's little that courts will be able to do about it. The other two aspects, the financial assault on universities that I mentioned, concerned tuition and philanthropy. Here, there's no doubt that what Congress has done is legal, will have a very harmful effect on universities, on faculty, and on education, but I don't see a successful way of challenging it in the courts. So the third and final part of my remarks, to what extent can we rely on the courts in the Supreme Court to protect higher education? For that matter, to what extent can we rely on the courts and the Supreme Court to protect our democracy? At this moment, the only possible answer is it's impossible to know. So far, the lower federal courts, the federal district courts and federal courts of appeals, have almost across the board found actions by the Trump administration to be illegal and unconstitutional. And this is true whether those judges were appointed by Democratic or Republican presidents. But when the matters have come to the Supreme Court, it's been a very different story. By my count, 39 matters have come to the Supreme Court since January 20th, challenging actions of the Trump administration. All are instances where the lower courts ruled against the Trump administration. And in 36 of 39, the Supreme Court has ruled in favor of the Trump administration. The ones that are most relevant to all of us who work in higher education are the Supreme Court cases involving termination of federal grants. And there have been 3 such cases. The first of these was AIDS Vaccine Coalition versus Department of State. It was on March 5th. It involved the Trump administration cutting off a great deal of money, the United States Agency for International Development. A federal district court judge found this to be illegal. He ordered that the money be spent. The Federal Court of Appeals agreed. The Supreme Court, 5-4, also agreed. Here, Chief Justice Roberts and Justice Barrett joined Justice Sotomayor, Kagan, and Jackson and said that the money needed to be restored, and all the district court needed to do was clarify exactly what dollars had to be reinstated. But a month later, the Supreme Court decided Department of Education versus California. This involved the Department of Education cutting off $65 million of teacher training grants. A federal district court in Boston issued a temporary restraining order saying it was illegal. The United States Court of Appeals for Circuit said, we don't review temporary restraining orders. We have to wait till there's a preliminary injunction. But the Supreme Court stepped in and in a 5-4 decision reversed the lower courts. Here, Justice Barrett joined with the conservative justices Thomas, Alito, Gorsuch, and Kavanaugh. It's a short, couple-of-page opinion from the court, and it says, grants from the federal government are like contracts. Claims for breach of contract against the federal government have to go to the Court of Federal Claims. They can't go to federal district court. And then the Supreme Court in a paragraph said, if the federal government is forced to reinstate this money, and that's later found to be wrongful, how will the federal government get the money back? Strong dissenting opinion explaining that grants aren't contracts. Besides that, if we're going to balance the equities, why aren't we also thinking about the harm to those who are not going to have the money they were depending on? And then the Supreme Court followed this up on August 21st in National Institutes of Health versus American Public Health Association. A federal judge in Boston found that the cutoff of funds by the National Institutes of Health violated the Administrative Procedures Act. I said a moment ago, that prohibits arbitrary, capricious, and abuse of discretion actions. He ordered hundreds of millions of dollars of grants restored. The Federal Court of Appeals agreed, but the Supreme Court 5-4 reversed. Again, it was the conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Chief Justice Roberts joined with the liberal justices, Sotomayor, Kagan, and Jackson. And again, it said, grants are like contracts. Breach of contract actions can't go to a federal trial court. They've got to go to the Court of Federal Claims. And the court was very concerned that the federal government had to give the money back. How would it ever recover it if that was found to be a wrongful order? Now, this doesn't preclude suing the government in the Court of Federal Claims. It doesn't preclude a suit like the one I'm involved in that's on behalf of individual faculty and researchers who are not parties to the contract. It doesn't decide the First Amendment question. All of that is left to be resolved. My optimistic self believes that the United States Supreme Court will stand up for higher education. After all, 4 of the justices on the Supreme Court went to Harvard Law School. 4 went to Yale Law School. They certainly should value higher education. Or on the other hand, will the Supreme Court just prove to be a rubber stamp for the Trump administration? And if so, what's that going to mean for our democracy? Ultimately, I believe the guardrail of our democracy has to be the courts in the Supreme Court. Certainly, checks aren't going to come from those around President Trump. Does anyone believe that Pete Hegseth or Pam Bondi or Kash Patel are going to say no, or Lyndon McMahon is going to say no with regard to education? Congress has proven not to be a check on the president. So the question is, will the federal courts, will the Supreme Court uphold the Constitution and laws of the United States? This, I think, is the crucial question as we go forward into the months and next few years ahead. To bring this back to all of us, I spent a lot of time in recent months going back and reading about the McCarthy era. And there are parallels between this time and that, both very bleak times for higher education. There's also ways in which it's not analogous. It wasn't the President of the United States leading the attack on higher education during the McCarthy era. There wasn't the financial assault on universities during the McCarthy era. But the one thing that the McCarthy era should say to all of us is that history will judge us. 20, 30, 50, 75 years from now, people will look back on us the way we look at university officials from the McCarthy era. And they will judge us. They will judge us as to whether we capitulated or whether we had courage. Thank you.
So friends, as Erwin takes a sip of water, I just want to tell all of you, because I'm not sure you can see, he did not have any notes during those remarks. I just want to start with that. That's not a question. That's just a statement. Okay, so Erwin, thank you very much for that incredibly helpful landscape view of what I will somewhat minimally call headwinds to describe the moment that we find ourselves in. I want to ask a bit of a landscape question, because this audience, as you probably know, has a very wide range of roles and perspectives across higher education. We have a very wide range of institutions here, although we have a spine of mission and public service and serving our communities. And there are probably several lawyers in the room, but definitely not a room of lawyers. So if I were to ask you a very basic question, why should we care about whether it is the Supreme Court or whether the Supreme Court is enforcing the law? Can you just give us that landscape answer so we understand the seriousness of the moment that we're in?
Sure. I can answer the question with a question, after I'm a law professor. And it's, what makes the Constitution different from all other laws?
Exactly.
What makes the Constitution different is it's so much more difficult to change. Anything Congress does, Congress can change next year. Anything your state legislature does, your state legislature can change. But the Constitution is enormously difficult to change. It's only been amended 27 times since 1787, and only 17 since 1791, and 2 of those were to create and repeal prohibition. But then the question becomes, why would a nation that thinks of itself as a democracy want to constitute itself in a document that's so difficult to change? And the reason is that the framers were so deeply distrustful of majorities. They wanted to put our most precious commitments, the structure of government, individual rights, into a document difficult to change. In this sense, the Constitution is an elaborate edifice to make sure that our short-term feelings don't cause us to lose sight of our long-term commitments. Everyone here is probably familiar with the story of Ulysses and the siren. How Ulysses wanted to hear the beautiful song of the siren, but didn't want to have to crash his boat on the rocky shoal like others. So he plugged his ears with wax. His sailors plugged their ears with wax so he could hear it but not be tempted. I think the Constitution is the same thing. We're tying our hands so that we're not tempted in the short term. And if you look through history, it's often been the Constitution that's been all that's there to save democracy. And too often our Constitution has failed us. But I think if there is going to be a check on a president who has authoritarian impulses, it's going to have to be from the restraints of the Constitution. And the only way we can enforce those is the courts.
So let me follow up on that. So when you say the only way we can enforce that is the court, I think everybody knows that the Supreme Court, supreme, very clearly indicating that it is the last arbiter of the interpretation of the Constitution. Is there any other structure other than the courts that would allow us to ensure that our democracy endures?
In theory, of course, Congress can check the president. Congress can pass laws restricting what the president does. Congress can put strings on grants telling the president that the money can only be used for certain conditions. Congress, in theory, could impeach and remove the president. At this moment in time, 9.5 months into the Trump presidency, Congress has not served a check on the president. Whether it will, we don't know at this moment. And ultimately, the people are a check. Democracies die only when they're silenced. Democracies don't die over the will of the people. And so, in the end, I think the check on what the president can do is up to all of us in terms of whether we speak out or are silent.
So I think you won't find much disagreement about that in this room. The idea, though, is what makes people want to speak out. And you've written extensively on trust in institutions and the idea of those of us who are not in the courts or aren't elected officials, what can we do and what would motivate us to do it? There's a pretty significant conversation in our universe about the loss of trust in higher education and what our roles and responsibilities are, because you're looking at a room full of people who care deeply and are doing good work and are motivated every morning to do good work. What do you see as the nature of trust in the general population and what we should be doing about it?
I think what's important is that the loss of trust in higher education is part of a loss of trust in all of the institutions in our society. Let's take Congress. I saw recently a poll that Congress approval rating is 16, and that might be 16 people, not 16%. The Supreme Court has its lowest approval ratings in history. A recent poll showed 30% approval and 65% disapproval of the Supreme Court. Obviously, the president and the prior president of a different party had approval ratings were often in the mid-30s. And so I think the loss of confidence in higher education is in part about a loss of faith in the institutions of our society. And then that goes to where I began. Can a democracy survive if people don't have any faith in the institutions of democracy?
So if we were to follow on that specifically for higher ed, a lot of the conversation about higher ed has focused on the institutions that have been in the sights of the administration, which are a particular category of institutions, those doing the highest amounts of research, those with the biggest national brands, and with a variety of other attributes that we could probably list. Some of those institutions are in this room. A lot of the institutions in this room have very regionally focused missions, primarily teaching missions, and are, while sharing the core ideals of serving, research, teaching, and service, would do so in very different ways. Is there any thought on how we would tailor your advice given the type of mission we collectively share?
I'd be presumptuous if I gave advice, but I'll just offer this as a thought. I know a core characteristic of land-grant universities is access to higher education. And one of the things that I think educators, and I among them, fail to do is clearly explain to people why higher education matters so much. It is the engine for social mobility. I'm the first in my family to go to college. Neither my parents nor brother or sister went to college. I wouldn't be here if it wasn't for scholarships that I was able to get to go to college and be able to pay for law school through loans. Every study, and each of you in this room knows them better than I do, shows that those who go to college have higher earnings than those who don't. Those who go to graduate and professional school have higher earnings than those who don't. In our increasingly technological society, having college and advanced degrees becomes even more important. And yet what we have to do as educators is find a way of communicating that to the general public.
we're all just going to nod at you when you say that, I think. Let's talk about communication and more specifically free speech, which is something, of course, that you are one of the most noted scholars in and frequent writer, both in scholarly circles, but also very helpfully for the popular press in ways that are very digestible. You're a very strong advocate for free speech, and you talk about the importance of it and our obligation as public institutions in particular to uphold it, and how it's an important component of being an educated person and providing a robust educational environment. Can you talk us through this complexity right now from your point of view as a legal scholar and what you think we should be thinking about as the broad administration of higher ed?
There's always an impulse to want to stop the speech that we don't like. And sometimes it's a very noble impulse. We protect freedom of speech because it affects, and those effects can be positive, but the effects of speech can be very negative. But what I always try to communicate to my students is that the only way my speech can be protected tomorrow is to safeguard the speech that I don't like today. And so I think it's important to start with very basic principles of free speech, and for that matter, it's related to academic freedom. And that's that all ideas and views can be expressed on a campus, period. And part of our responsibility as university administrators is to explain why that's essential and then to protect the ability for every idea and view, even unpalatable ones, to be able to be expressed.
So you've certainly spoken consistently in that way, and you've also been very clear about how the expression of provocative views shouldn't cross over into disruption. And of course, you've very publicly experienced that yourself. Can you talk us through how we strike a balance between the robustness of diversity viewpoint and the actual function of the institution?
There have been a number of unfortunate incidents, often at law schools, some, as you allude to, at my law school, where events have been disrupted. And what I become convinced of is that it requires several things. First, it requires a clear statement to the university community that there is no right to disrupt activities, that your free speech rights doesn't give you the ability to use them to silence others. Otherwise, the only speech we'd ever hear is that which no one cares enough to silence. And so there has to be a clear statement in terms of expectation. Second, there have to be policies. There need to be policies in place that say that if you disrupt, you will be disciplined. And third, there has to be enforcement. The policies are meaningless if students know that they can be ignored. And so when there are disruptions, then the students who are responsible have to face discipline. Now, of course, what also has to explain to students is that if they dislike a speaker, they can have peaceful protests. They can bring in their own speaker. But once more, if we don't follow this policy, then tomorrow their speech can be disrupted and we'll never hear anything. And so I think it's a combination of clear statements, policies, and enforcement with regard to preventing disruptions.
Mm-hmm. So just for everybody's benefit, this will be, I think, your second book with Howard is coming out imminently, and it's called Campus Speech and Academic Freedom. And it's essentially a guidebook, right? So who was the intended audience of that book?
Oh, we're authors. We want as wide an audience as we can possibly get. But more than else, it's written for you, for university administrators. We tried when we did Free Speech in Campus, which we wrote in 2016, was published in 2017, to try to make it very practical. We don't want to be presumptuous and give advice to anybody, but we do want to make very clear, this is what the First Amendment allows, this is what isn't allowed, and then offer some of our thoughts about how university administrators should proceed with regard to speech. It's interesting, as I said, Free Speech on Campus was written in 2016, and we recognized a couple of years ago that so many issues had arisen that we couldn't possibly have anticipated. The state laws with regard to critical race theory in DEI, the encampments across campuses in the spring of '24, the disruptions that you mentioned. And so we said we didn't want to do a second edition of the book, but wrote a very different book, though obviously on many of the same themes, dealing with the kinds of issues that are arising on all of your campuses now.
Can we go a little deeper into something that you look at in the book, which is academic freedom, which is a term that's used very broadly, but I suspect if we took a poll would be defined in a multitude of ways by this audience, and then even more so if we were to ask our faculty and students, most of whom are not represented here. Could you give us a primer on that?
Sure. Academic freedom under AAUP guidelines going back over a century protect for faculty their ability to research, to teach, to express the research without controls, but having to meet professional standards. I often describe academic freedom in the First Amendment as in a Venn diagram sense, overlapping circles. There's some things that are protected by First Amendment that wouldn't be protected by academic freedom. Imagine that a faculty member at one of your universities goes to a very controversial rally over the weekend, and there's a call to discipline that faculty member. Well, the First Amendment would protect what the faculty member did, but academic freedom wouldn't, because in my hypothetical, it wasn't about the faculty member's research, teaching, or public dissemination of that research. On the other hand, there's some things that are protected by academic freedom that aren't protected by the First Amendment. The most obvious example is the First Amendment applies only to government institutions. Private institutions aren't governed by the First Amendment. Academic freedom would still be there, but not the First Amendment. And of course, there's much that's protected by both the First Amendment and by academic freedom. If a professor were to be disciplined for a scholarly article at a public university, that would raise both First Amendment and academic freedom questions. But I think what's often omitted from the discussion of academic freedom is that it's governed by professional standards. That if a professor in one of your history departments wanted to teach that the Holocaust didn't happen, or a geology professor wanted to teach that it was a flat earth, you'd be able to discipline that professor. If I assign someone to teach contract law, and he says, I don't want to do that, I'm going to protest by just talking about sports, I could discipline that professor. Academic freedom, like free speech, is not absolute, and academic freedom has to be exercised in accordance with the professional standards.
Do you have a sense, since you look at the law in a very legal sense, forgive me, but also you look at the impact of how all of this is affecting trust, that the way in which academic freedom is relied upon has had any impact on the way the general population feels in terms of trust?
I don't think that the general population understands academic freedom. I don't think as a concept it would have a great deal of appeal to the general public unless it's explained. Because most people work at jobs where their speech is restricted. Mm-hmm. If you work at Home Depot, your ability to wear buttons that express political messages can be limited. There's a recent decision of the United States Court of Appeals for the Sixth Circuit saying exactly that. So if most people don't have free speech on their jobs, it's hard for them to understand why is it that academic freedom matters. And so again, I think this is a place where we've not communicated widely what academic freedom means. And I even think among faculty sometimes there's not a full understanding of academic freedom. I've too often heard people say, well, I have academic freedom to do that, when it has nothing to do with academic freedom. It's just their preference to act in a certain way.
Mm-hmm. All right, let's pivot and talk about technology. So I'm going to ask the broad question and then we'll dive in. How do you see technology in its power, but also in its risk, affecting our mission and the things that we hope to and are charged to do?
I'm probably not the right person to answer that question. I can just speak from my perspective in terms of the kinds of issues we deal with. The one thing that I believe is that universities will be fundamentally the same 20, 50, maybe even 100 years from now as they've been before. And I realize that's a controversial statement, but I went to law school 50 years ago, and legal education is much more like what it was 50 years ago than different from it. I started college in 1971. College education is remarkably the same now as it was then. Yes, students take notes on laptops. Yes, there's access to instant information over the internet. But basic teaching and learning has been the same for centuries and will continue to be. Now, that doesn't minimize the importance of technology, and the technology now we most have to focus on is artificial intelligence. And I'm sure you have experts far more than me to talk about that. But what we're struggling with in my law school, and I think generally in legal education, is simultaneously how to train our students to use artificial intelligence so they'll be prepared for legal practice, but also preventing artificial intelligence from being used that undermines the integrity of our grading system. And I think this is a tension that every school faces, and we don't have answers right now. It's too new a technology.
Mm-hmm. I think that was really what I was getting at, is that in the way that many of us do our work in this room, some people in here teach, a lot of people in here do the other incredibly important work that makes the university run and makes us be in the position to serve our students. And the nature of and speed of artificial intelligence, there's all the concerns in our sector that there are in any sector in terms of our employment and how our work will be done. But I think there's also this sense of AI itself affecting the trust in institutions or the legal boundaries of institutions and what that might mean.
And it's so very difficult at this moment in time for anyone to answer that question. I mean, who heard of ChatGPT more than a few years ago? And ChatGPT is just one of so many AI programs. And so how do we train our students to use it? How do we prepare them for a job market that will change because of it? But how do we also protect the integrity of our grading system? I'm sure most of you saw an op-ed in the New York Times several months ago where somebody said the only solution with regard to cheating is to go back to handwritten exams in blue books. I'm teaching 200 students criminal procedure this semester. Law professors grade their own exams. I will tell you, if we go back to handwritten exams in blue books, I'm either retiring or teaching only seminars.
Those of us who went to law school during the Blue Book era, our hands are cramping just at the thought of what you're describing. Okay, so Erwin, as we wrap up, I know you said you didn't think you should be giving us advice, but we want advice anyway, so I'm going to ask you. We're at a moment in higher education as one of the institutions that is a cornerstone to what it means to be this country. We very proudly serve our students and engage in community service and have global partnerships and try to elevate our communities in concentric circles from our neighborhood to across the world. And so we are both at a key moment for opportunity, but at a key moment for challenge in terms of our core mission and contribution to what makes this country great. Do you have advice for us on how we gather our resources to both endure and to make sure that what is critical to what we do also endures?
Not only does it feel presumptuous to give advice, but I don't know anything to say that's beyond the obvious. It seems at this moment in time it's so essential that we remind ourselves of our central missions and commit ourselves to those central missions again. And it's so essential that we work together and that there be unity with regard to our commitment to that mission. Let me talk again about my field, law. When the president targeted a law firm and did so entirely for retribution, he said the reason he was going after the law firm of Perkins Coie was because they had represented Hillary Clinton. If every law firm had stood up to the president, this would have gone away. But instead, what ended up happening is 4 law firms challenged in court. All have won so far, and other law firms capitulated and paid over $1 billion. The one thing we all learned on the playground is if you give in to a bully, it only makes it worse in the long term. So my answer to you is, I think it's so important that institutions of higher education stand together at this moment and stand together for our shared missions with regard to research and education.
And with that, Erwin, thank you very much. Let's give Erwin a round of applause.
Thank you.
Thank you. It's fantastic.
Thank you. I have it all put together.
Yeah, it's a good group, and they needed to hear from you.
Thank you so much.
Please welcome APLU President Waded Cruzado.
I hope you agree we could not have found a better speaker to wrap up our meeting. One more time. Before we depart this morning, first of all, I have some messages of gratitude to share. First of all, please help me thank again Temple University, University of Pittsburgh, and Penn State University for hosting APLU annual meeting. And if I may impose on you with a personal request, can you please help me thank the wonderful APLU staff for all the wonderful things that they have done. And to you, our wonderful APLU members, thanks for your support. Thanks for being member institutions. And I hope that with this meeting, we have given you some very valuable tools to continue to rise to the moment. As we celebrate Veterans Day and we thank wonderful veterans for their service, please go back home safely, safe travels, and we see you in San Antonio next year. Thanks for being here.